Sparkman from the FDLE, who is the supervisor of the purchase of firearms. And, oh yes, if you have the application on your smartphone, you can download it and do the evaluation. Thank you. Oh, you love the prize of the test. Is that what you're looking for? Oh, so you're for that. You didn't want it. Okay. Anyway, Robin Sparkman will talk to you about mental health.
Good morning. As Cindy stated, I'm Robin Sparkman. I'm with FDLE. I'm the supervisor of the Firearm Purchase Program. That is the group of individuals that test you to see if you can operate small electronic devices. It's a group of about 62 individuals. We run a call center and a research center, and we do all background checks in the state of Florida for individuals who go to a federally licensed firearm dealer to purchase a firearm. Just a little bit of history about what we do. The Gun Control Act of 1968 indicates there are 10 reasons, federal disqualifiers, why an individual would not be eligible to purchase a firearm. And then in Florida, we have 3 additional state disqualifiers that we have to evaluate that we have to use when we're evaluating an individual for fitness to purchase. So the Gun Control Act of 1968 was the foundation for this. And back then, the individual, when they came to the firearms dealer, they would be handed a form and they would have to say, no, I'm not a convicted felon, no, I don't have any injunctions for protection against me, no. And we just took their word for it, and they were sold the gun. So in 1991, FDLE stood up its call center for its firearm purchase program, and we began running background checks ahead of the Brady Handgun Violence Prevention Act that was passed in 1993 that actually required it. So we were just a little bit ahead of the curve on that. But in 1993, the Brady Handgun Violence Prevention Act was passed as a result of the attack on President Reagan's life that also disabled his secretary, Brady, at the time. And so that act was passed as a response to that tragic event. It says you must run the background check, which we already did. And it stood up a center at the FBI called NICS, which is the National Instant Background Check System. And NICS is used now as a database to house data that's not found in other files. So when we have criminal information on an individual, those are housed in our criminal justice system. But when we have non-criminal information, disqualifiers such as mental illness or mental health disqualifiers, those disqualifiers are housed then in the NICS system, and that's how we access that to evaluate it for the fitness of purchase. In 2007, after the Virginia Tech tragedy, we stood up here in Florida a database called the Mental Competency Database, or MECOM. And it was established to receive and store to be a repository for mental health records that were disqualifiers for the purchase of a firearm. The 2007 law amended statute 790.065 to say that we must have the repository ready and available for clerks to use, and that it defined which records were added to the repository. It required the clerks to submit those records within 1 month of the order, and at a minimum, it required the submission of the name, any alias known names, the gender, and the date of birth of the individual upon which the order is done. So who did it apply to? The statute in both federal code, or the language in both federal code and statute, is the term mental defective, which is offensive to many, especially in the healthcare industry. But nonetheless, it is the term that is currently in use. And it is basically defined as a marked subnormal intelligence or mental illness incompetency, condition, or disease, where the subject is a danger to himself, herself, or others, lacks the mental capacity to manage his or her own affairs, so a guardianship issue. And that includes a judicial finding that the subject is incompetent to stand trial, and any acquittals by reason of insanity. So those individuals should be submitted, those court orders on those individuals should be submitted for inclusion into the MECOM database. When they're loaded into the MECOM database, they are automatically shared in the national system. And the benefit of that is if an individual who is found to be one of those in Florida goes out of state and attempts to purchase a firearm, then he or she would be denied nationwide, regardless of where they go. The same is true for other states. When they share their data, then if that individual comes to Florida, and we have a high transient population, but when that individual comes to Florida, then that individual is disqualified here as well for purchasing a firearm. It applies to involuntary commitments, the law in 2007 as it was passed. For anyone who's committed for mental defectiveness, mental illness, or substance abuse, to include inpatient and outpatient treatment. Involuntary assessment stabilization under the Marchman Act, and treatment orders under the Marchman Act. It does not include, and was never meant to include, individuals who sought help on a completely voluntary basis. We don't want it to be a punitive thing where people then are now afraid to seek help, so it does not include them. It does not include anyone who was discharged after an assessment because they did not meet criteria, and it doesn't include anyone who voluntarily admits themselves to a mental institution. The new reporting requirements of House Bill 1355 became law July 1st, 2013. And really, right now, we have only one county in compliance, which is Hillsborough County. We have not received records from any other county. We've got about 430 in the last 7 months from Hillsborough County. So we've got this education effort going on to make everybody aware of what the law says, what the criteria are, and to let you know that we put together a work group of individuals from the various industries to include the Florida Psychiatric Association, Department of Children and Families, receiving and treatment facilities. We had a magistrate and a judge sit on the panel. We had a couple of attorneys on the panel, and together we discussed this issue through about 4 meetings and came up with some forms that could be used by facilities, by treatment facilities, by clerks, to comply with the statute as it was written. So basically now, the new law says, not just involuntary, but those people who come in on like a Baker Act or a Marchman Act, anything that's results in an involuntary assessment. And then after they have found to be met criteria, they switch to voluntary. Because that was a loophole in the old law. So if somebody could come in, they could be in imminent danger, they could have suicidal thoughts, they could have homicidal thoughts, and if they switched to voluntary, they didn't get reported. So this law was meant then to close that loophole so that those people got reported and included in the database. But these conditions must be met in order for them to be reported. First, the examining physician has to determine there is an element of imminent danger. So the person could or has threatened to harm himself, herself, or others. Second, that if the person had not said, I'm going to go voluntary, then the doctor would have done an involuntary. Or they've already started the involuntary and they're withdrawing it because the person is now involuntary. So either one of those must be met. Before agreeing to go voluntary, the person must have been found to be competent so they can sign their own paperwork, and receive notice of a finding of certification, received written notice that their firearm rights are going to be denied to them as a result of this process, and they have to have acknowledged that notice in writing. So because the law had all of these different components to it, that's why the work group was put together to try to come up with some forms and some solutions to some of the problems. And then the last condition is that the judge or magistrate has reviewed the record classifying the individual as imminent danger and has placed an order for such record and asked that that order be submitted to FDLE. So we've been kind of doing the traveling roadshow around Florida. We've gone to Tampa, Miami, West Palm, Tallahassee, Jacksonville yesterday, and we're going to be speaking in Orlando on February the 13th. And we have with us a panel of presenters. So you got short changed, you only got me today. But typically there are 5 of us that stand up and talk about this. And one of the co-presenters is Jane Castaner, and she's with Grace Point, a receiving facility in Hillsborough County. And she talks about specifically what the responsibilities of the receiving facilities are. Since you're not working receiving facilities, we're going to kind of light code that. But basically, she and the working group came up with some forms that the receiving facilities could use to meet the letter of the law, which included a cover sheet, the physician's finding and certification, the patient's notice and acknowledgement, the application for voluntary admission, which they're already doing, and then a petition, if it was filed, then an order to have that one taken back so that they can go voluntary. Now, the law states that the receiving facility has 24 hours to get this to the clerk's office. And it doesn't really give any provisions on how you're going to mark that 24 hours or how they're going to mark that 24 hours. But it's 24 hours from when the patient makes the decision to go voluntary is when they should be getting it to you. They don't get a waiver for nights or for weekends or holidays. They have 24 hours real time from when that patient makes that decision. Now, in Hillsborough County, to help the receiving facilities and to help the clerk make sure that those orders were being received in time, the IT person in Hillsborough County got with the IT person at a couple of the receiving facilities, and they set up a file transfer protocol site or an FTP site. So basically, instead of the receiving facilities getting in their car and driving to the clerk's office at the end of the day every day to drop off paperwork where a clerk then has to stamp them in quickly before the end of the day, they put these orders in there, all the paperwork in there in electronic format onto the FTP site. Then the site sends an email to the clerk saying, orders were posted from facility whatever at such and such time, so it timestamps it for them as well. And I understand that this is a very inexpensive and very easy solution for Hillsborough County to enact. So if any of you have any questions about how they did that, the person who's the point of contact there is Robin McCarty, McCarty. And she may be able to assist you in what they did to get that site set up and how simple it was. It was a no-cost solution for them, and it's been really working well. And then once the clerk gets the paperwork, they have 24 hours then to deal with it as well and get it to the judge. Now here are some, but those, as I understand, have some time variations because of the rules about how you calculate time over the weekends and holidays. So clerks get a buy for that, where the receiving facilities do not. This is the example of some of the forms that the working group came up with. This was the cover sheet, where it tells you what else is coming. And you notice at the bottom, even though the law said you have to report the name, the gender, and the date of birth, we've asked for the receiving facilities to add to that the race and the social security number. And in our trainings that we're doing around the state, we recognize and acknowledge that certain receiving facilities, legal counsel may counsel them against giving the entire social security number. We'll take the last four, if they'll write last four, and put it in there. And then you can enter that in the comments of DCOM, and it will help to identify. You have no idea how many Michael Smiths there are in the world, and some of them have date of birth that are the same. So when they go to purchase a gun or a firearm, they get denied, and it's not even their record that they're getting denied for. So having this additional information is extremely helpful to help us carry out our mission, which our mission is, number one, to make sure that law-abiding citizens are able to legally obtain firearms, which is their constitutional right, while, part two, preventing them from people who are disqualified. So the more identifying information we have, the better we can do our job. And we understand that that starts at the receiving facility. You can only deal with what you get. So we are asking them to do their best to provide as much information as they can to you. This is the finding of the physician's finding, and what's important on this form is this kind of comment section at the top where the physician will need to put in there some indication of imminent danger, such as patient has suicidal ideologies, patient has a violent history. If they just put in there, patient refuses to eat lunch every day, that's not going to help the judge to make a determination. So we're asking the receiving facilities to put information in there that the judge can use to certify that this individual is imminently dangerous and does qualify for retention and rehabilitation. And then here is where the patient actually acknowledges that his or her rights to a firearm are going to be restricted as a result of these proceedings. And this form has been separated from the others because the physician said, well, you know, in some facilities, an administrator is going to go over this where not the physician, so it's pulled out of the finding form, it's a separate form. And then here is the application for voluntary admission, which is the same as what they use right now, with the addition of a couple of lines to show that if they're voluntary, that this is going to comply with House Bill 1355. Then this is the judge's order, the court order to withdraw a petition that has already been filed for involuntary. If they've already filed one, then they're going to want to withdraw that so that the person can go voluntary. For the clerks, and you'll have to excuse me, I'm not a clerk, I've never worked in your offices, but Robin McCarty does an excellent job of presenting this when she does it. They enter the pleadings into the clerk's management system, into your own management system, and then submit the petition and other related documents to the judge or magistrate for review within 24 hours. The reason that the time clock is so accelerated on these voluntary admissions is because involuntary, you don't get to leave until they say you get to leave. On voluntary, they give you a notice and 24 hours later they can walk out the door. So if they give the notice and 24 hours later they walk out the door and go down to the gun shop and then commit suicide or worse yet, a Sandy Hook event, a Virginia Tech event, any of those, then that's what we really want to prevent. So the time clock on these voluntaries is much accelerated due to that. Again, there are administrative rules about how you calculate time that accommodates for nights, holidays, and weekends that I believe would help you adhere to that 24 hours. In the judiciary, the magistrate or the judge will review the records, the findings, the certification notice, the written acknowledgement. They'll make sure that everything is in order. That findings certification page has to contain the verbiage that allows the judge to understand that the person is an imminent danger, because that is a key component to this law. And then if the judge or magistrate determines that it does support, they will enter a finding and issue an order requiring the clerk's support to submit the record to FDLE. Again, here is a sample form that Hillsborough County is using. The magistrate down there is using for these orders. That's page 2 of it. There is also in law a requirement for a mechanism to then find relief or have those firearms rights restored. So you can't take something away without giving them, the public, a right to get it back. So the clerks, you may notice a sudden increase in calls to your agency asking you how people can restore their firearm rights. And the reason for that is the MECOM database was stood up in 2007. The rate of review for concealed weapons permits is 7 years. So we're just hitting that where people are coming up for review at that 7-year mark, where they've been entered in the database and they don't realize that they're in there for their Marchman Act issues or their post-bank issues. So when they get turned down for their concealed weapons permit, or they get turned down to purchase a firearm, we give them the case number and the county that entered the order. And they're going to contact you and ask what they can do to get their rights restored. So that's why you may suddenly see an increase in phone calls or queries or people showing up at the clerk's office asking how they can go about this. The petition, there is a petition for relief mechanism, and the working group drafted a packet that consists of the petition of relief for firearm disabilities and the notice of hearing that is required in law. This may be provided by the receiving facility if the receiving facility so wants to do it in order to facilitate that person's rights. There's no limit to how quickly they can get out of the hospital. They can get out of the hospital the very next day and file for their firearm rights to be restored. Or you can choose as a clerk to make that packet or something available at your office for their use. The petition is filed with the clerk of court for each order, and when I say each order, the individual may have had a commitment done in Pinellas County and another one in Orange County. They're going to have to file their relief in both counties to get relief from that order. The notice of hearing is prepared. We say is prepared, you don't say who prepares it, but somebody prepares a notice of hearing. That's for you to decide how that's going to be done in your county. And a copy of the petition of notice of hearing is forwarded to the state attorney, because the state attorney has the ability to be at that hearing and do cross-examination, ask questions. And in Hillsborough County, the state attorney there is very active and goes to each and every one of these, he's the state attorney, and fights them vigorously. They've only, I think, successfully processed about 8 or 9 of them. Here is the petition that the working group drafted as a sample form to both pages. There is an evidentiary hearing, as I indicated. The record of the hearing is kept by a court reporter, and then the final order is issued by the court. So the court must consider the petitioner's reputation, their mental health record, their history, any other circumstances surrounding the firearm disability and other evidence. Age may be a factor, previous police reports could be a factor, and then the court must find that the petitioner is not likely to act in a manner that is dangerous to public safety. If so, then the order is entered, and that's the sample form that the working group came up with. If it is granted, and there's proper notice of relief to the petitioner, FDLE will delete the records from our database. So you just send us the order. You can do it by fax, you can do it by attaching it to an email. It has to come from you, it cannot come from the petitioner. It has to come from the clerk's office. And then we will remove the order from the MECOM database and the national database. Like I said though, if that guy's got orders from 3 counties and we remove yours, he will still be disqualified from purchasing a firearm until the orders are removed from the other counties. If the firearm disability for relief is denied, then the petitioner may not petition again for 1 year. There's no time frame on how quickly they can petition after they get out of the hospital, but if they're denied, there's a 1-year limitation, they can't petition again. Or they can take it to the District Court of Appeals for another review, and perhaps it would be overturned at that level. Again, just to circle back to where we started, The mandatory fields for an entry into MECOM, into the database, are name, gender, and date of birth, and the uniform case number from your county. The record searches are based on name, race, sex, date of birth, and social are usually what we put in, but when there's no social to match up to, often we get back records that do not actually identify the person that we queried. So that additional information, those additional subject record identifiers, are very helpful for us to make sure that we can complete our job properly. So if you get them from the receiving facility, please include them in your entries into MECOM. Providing these really helps us to facilitate those background checks in a much quicker way. If we deny somebody because the identifiers are very close, one day off on the date of birth, for example, then that person has to go through an appeals process. The appeals process can take 6 weeks. So it's very important that we try to get this right the first time so that we don't hold somebody up who's legally able to purchase a gun. I can tell you that there has been a California sheriff about 2 weeks ago that was denied the purchase of a firearm because he was in the mental health database. Only it wasn't him. It was a name and a date of birth exactly the same as him. So he had to file for an appeal the same as everybody else has to file for an appeal. And certainly, he would be able to purchase a firearm. Windows is not. These are the resources, the phone numbers that we gave all of the attendees at each of the training sessions. You'll see that the Florida Clerk, Courts, and Comptroller's phone number is up here. We did provide that to them. And our number's at the bottom. There's been some debate on where the forms, the sample forms of the work group will be posted. Probably on FDLE's website, probably on DCF's website. We're really, as we go through the stage and we talk to people, we get more input from them on questions, and the forms are being refined. Somebody just yesterday was like, well, if you could stick an "and" in there, that would really help us. So until we get all the way through the stage and we get the feedback and input from everybody that we've talked to, we don't want to post anything because they continue to be improved. You guys are the subject matter experts. You work this stuff every day. Really, while the work group was well represented as subject matter experts, we really want to get feedback and buy-in from everybody. And then once we have that, we'll post the forms and we'll let everybody know. I'm sure the FCCC will make some sort of announcement on their website as to where you could go to view those sample forms. Have any questions?
The best practices, well, I've got some best practices work group is working on getting the best practices on this topic. And we'll also be working on a packet that Robin was talking about. So that way, you'll be able to hand it to the person coming in saying they're going to regain your rights. And we'll have a petition, we'll have a notice of hearing, and we'll have instructions. This way, when they start to ask you questions, you can just refer them to this packet with that instruction, so that way you can work out. And as soon as that is completed and approved, we'll have it on the internet, and we'll also do the web access as well.
Is there any thought using e-forms
Well, right now, it's only the attorneys that are able to file. So once there's other users that are permitted to file it, then yes, they'll just file it that way.
One question. So FDLE had contacted FDLE, and they came over actually and did some research on some mental health records and some records. And then it says the list of statute numbers that we were supposed to report to them. So when I went into therapy and set up those statute numbers for assessments and stabilization and printed out a report from 2007 and up, should I not have done that?
No, the report, the clerk's reporting to FDLE can take several formats. So we do have direct access into the BCOM database. We can assign usernames and passwords for each of your users that you want to do it, and you can take control of your records. And we really encourage you to do that because you can run reports on what's in there for your county and that sort of thing. So that anybody who doesn't have direct access to BCOM, who would like to have direct access to BCOM, we have a email address, which is bcom@fdle.state.fl.us, and you can email us and we'll give you a form to get your message on. And the law required electronic submission. So some people say, well, that's a fax, that's electronic. So they fax us their orders, and then we have staff that enter them on your behalf. And then we had some grant money that allowed us to actually have somebody come to your county and help do the research, because when we contacted clerks, a lot of times they said, you know, resources is an issue for us. We don't have somebody who can just sit here and go back over 5 years worth of data and try to find this for you. So we did hire some people on grant, some OPS people on grant staff who came out to the counties and did the research and got the list of orders, or maybe you provided it to us, and then the entry was done by FDLE staff. So we have a variety of means to get it in there. To us, you know, when we get challenged, it's not generally quiet. It's in a very public way. You know, it's by the New York Times, or by the Herald, or USA Today. It's all over the internet. So when one of these tragic events happens, you know, it's unfortunate, but the first thing that people do is try to turn a finger at somebody. And so it's, you know, we're usually in that first line of attack. FDLE, how did this happen? How did this person who was clearly mentally incompetent get their hands on this firearm? And so our effort was just, let's get them in there. Whatever we have to do to get them in there. Whether we have to do the work, if we get some grant money to do it, whatever, let's get them in there. So that was the effort.
I have a couple of questions. I don't remember the law specifically, but using your example of the sheriff, who is not a person who was involuntary or voluntarily committed, what's the jurisdiction for the petition being filed? What county is that person supposed to file it?
For the relief,
Yeah.
then they would file with the county where the order was entered. And we, in the appeals process, when that person appeals their denial, we supply them with the uniform case number in the county.
Okay, and so the petition, typically petitions initiate an action, and they are accompanied by filing fees. Are those exempt under the statute?
I do not know the answer.
They are, Cindy?
Yes, there is a,
Okay, so, and these petitions are initiating a relief case, or they're being filed in the,
they're being filed in original file.
even though in the sheriff case, it has nothing to do with this person. So all of his documentation for relief is going to be in someone else's file. That makes no sense.
Well, in the case of an appeal, the sheriff would be contacting you. First of all, we contact you. That's the first line of defense in the case of an appeal. We contact you and we say, do you have any other piece of information that would help us differentiate Sheriff Smith from this Michael Smith? So we try, first line of defense, not to let that happen. So that's the first thing. Only after we determine that we either can't go forward because that's all the information we have, or we determine that that is in fact Sheriff Smith, who has been declared mentally incompetent in your county, do we say, you gotta take it up with them now. We're honestly denying you on information we have to be clear and factual and truthful. And we have to deny you based on this information. So now, if you feel you're in there incorrectly, if you feel they typoed this date of birth when they put it in, if you feel they did something wrong, you're gonna have to take it up with the record owner, which we're just the repository. So we're not the record owner, and we don't change records that you submit to us unless you tell us.
But that appeal is filed at FDLE.
The appeal is filed with us. That's always the first line, and we always try to rectify that before we put them up on the always. Yes, sir.
Can you tell us how the access to the software?
provided it to FCCC.
It would be on the internet. The conference, within the conference.
So one more question.
Sure.
Somebody comes in and files a petition to stabilize and assess somebody. We open up the case. The judge signs the order, kind of, sending them over to get stabilized, assessed and stabilized. Nothing else happens on the case. FDLE told me that is one of the statutes they're supposed to put in the NECOM. Is that correct?
And there's some debate on
Because
that.
they didn't
Right.
have a long-term truth agreement, that's what I'm fighting.
Right, so we actually had a debate open on that the other day when we did our presentation in Tallahassee. And we're gonna go back and review what our legal counsel has provided us and give an opinion.
Because I've already submitted them, because they said they needed them, so I'm concerned now in my county, and I've submitted all those records to you guys.
And the second line of defense is, in light of the hurry to get this up and running and everything in there, now we've got that opportunity to take a little bit of a breath and do an audit of what's in there. So that's gonna be where we're headed next, to allow you, to provide you back the records that we have entered on your behalf, and allow you to audit it and us to audit it, which is gonna do several things for us. It's gonna help us to make sure that the records that are in there are accurate and correct and should actually be in there. And it's also gonna allow us to establish some baseline for some specific demographics. A county of this size with this demographic should have approximately between this and this orders entered in the system. And that way, if a county that size does not, we can go to them and say, this is what we would expect to see from your county, and we're seeing something that's way, way under or way, way over. Let's see if we have a problem here, and it'll allow us to investigate that. So that's where we're headed next, is to do some audits and to do some baseline analysis so that we can better determine what should be and should not be in the system. And if there's anybody who needs some assistance, some resources, we still have a little bit of grant money, and we're still going to honor it.
So, we send the orders to make the judge incompetent to stand trial. When they go through the process, we get an order back saying, now they're competent to stand trial. When we send that to you, that still does not take them out of the.
No, that takes them out. So if you send us an order that says that they're competent to stand trial, and we run everything by our legal before we do anything with it, and then they tell us this qualifies for deletion or it does not qualify for deletion, and then we take it out.
We're actually in a county that doesn't have a facility like what's made Baker Act or Marcia.
Right.
We just have an initial assessment, then they're sent to Bay County.
Right.
So if any further treatment, we never know because we never did it.
Right. And that's true of about 10 or 12 counties that don't have receiving facilities in the county, the more rural counties. And it's across the nearest facilities across the line in Shenandoah County. So therefore, subsequent petitions are filed in the other county.
We have been a problem with our receiving facility, not doing this demographic.
Right.
We asked them, we created a demographic form and asked them if they would be willing to submit that with petitions or their work, and they did, and they refused because they said they didn't laws that they couldn't do that.
So to address HIPAA, we have two efforts coming up. One of them is the recent presidential announcement to relax HIPAA standards for the use of mental health data as a firearm disqualifier. So that's been posted to the Federal Register as a recommended policy at this time, and it will go through the process. So that's one of the mechanisms that's going to be in place to help with that issue. And then the second one is for the voluntaries, this acknowledgement form. We actually have a medical facility that's working on maybe inserting a line into it where the individual understands that his information or her information is going to be used for this purpose, so it's a waiver for their medical rights as well. So we are aware that that's an issue. And there are treatment facilities whose legal counsel is saying, don't provide it. The law says you have to give 1, 2, and 3. That's all you're getting, and at that point, we're kind of stuck. But to help in that effort, we have identified what we call glitches with the bill, several glitches, loopholes, issues,
So the second portion of our session today is some additional work that's been done by the Best Practices Committee on release orders. So Gypsy and Liz, if you want to come. And just a reminder, if you came in a little late, the sign-in sheets are over on the right-hand table. You can sign them on your way out. You can fill out your training evaluation forms for this session through the FCC application for your smartphone, or you have the paper forms over there, which I can pass out if you just raise your hand. But to get started, I would like to introduce Honorable Marcia Johnson, Franklin County Clerk Report, and our Chair of the Best Practices Committee.
I'm just going to be real brief. As chair of the best practices, I work alongside 15 other clerks who are on the committee alongside me. And over the years, our staff have come together, and I just want to say a big thank you for our staff coming together as common cause to help all of the clerks be more consistent with our procedures. And these people like Gypsy and Lewis, they form friendships. They connected the staff of FACC, Cindy Andrews, Sarah Sanders, Randy Long. They've connected with staff of ours. It's just for the good of all of our offices in the end to come up with these procedures that we all can be uniform in what we're doing. This morning we had Louis Tomeo, he's the criminal court director of Palm Beach County, Gypsy Bailey, that I've known for years, and I email her all the time, and so helpful too. She's the staff counsel and director of court services for lead on him. So I'm going to turn it over to you.
Thank you. Good morning. I'm sure everyone knows that in October 2013 there were some fraudulent court orders that got into the Clerk system that resulted in the release of 8 inmates. And based on that issue, the Best Practices Committee formed a work group that Gypsy and I are a part of in Dade County. Diane Pagadine is in the audience, and Alachua County, and Marion County, and a host of others, to recommend these best practices to the Best Practices Committee. So this is just a recommendation at this point. The best practice recommendation has not been approved by the committee yet. So, draft bill Senate 592 that upon passage would become effective July 1st, 2014. And our interpretation of it is basically two things. It deals with authenticating court orders that deal with the release of inmates. So the first part of it basically states that the DOC would verify the authenticity with the issuing judge. But that doesn't impact the vote. That's the process that is used. Or, if orders received from the clerk, it must be accompanied by the confirmation from the issuing judge or designee the authenticity of that order. And that's the process that we're going to focus on today. In order to comply with the Senate Bill 592, we believe that a recommended process should be followed. It would provide a methodology to handle reduction of sentence orders in a secure environment with appropriate validation in place. The key components to this process is a court verification form. This form would be used for every reduction of sentence order issued in court, both a verbal order or a written order. We also recommend that these orders are transmitted to either the local jail detention facility or the DOC via secured process, and we recommend email. And then a point of contact be established with the DOC or the local jail facility so they can contact you or you can contact them if there's any questions regarding the authenticity of the order. Our research showed that there are 3 main inputs in receiving orders into the clerk's office that impact one's release. Through the in-court process, where the judge signs the order in court and hands it to the courtroom clerk. Out of court, where the judge signs the order in chambers and those orders are typically picked up by the clerk courier or perhaps the court JA or other court staff delivering it to the clerk's office, or direct pickup, which is through a U.S. mail, an inbox, or a non-clerk or court courier. We created a workflow that we feel would be an appropriate process for this release order best practice. The key that we feel that makes the whole process work is the rectangular box under the oval box, where the judge is to prepare his court verification form indicating whether the order is legitimate or not. And we send that form along with the court order to the clerk. Now, I'm going to speak to in-court and out-of-court sections today. And Gypsy is going to speak to direct pickup and not legitimate orders. This is the court verification form, in the draft form that we developed. It's a very simple form. The court would fill out the top part, and the clerk would fill out the bottom part. Basically, it's the case number, defendant's name, the type of order, and we listed the most common orders on there: modified sentence, reduced sentence, change sentence, release sentence, and the left an other box. And then the judge or designee would check off, verified as legitimate, put the date, sign it, and put their name under it. Now, we know that there's over 900 judges in the state, and not all judges are probably going to be amenable to filling out these orders. And we do realize that in some places or some judges will be asking the clerks to prepare these orders. And that would be up to the individual clerk's office. That's the process. So, in court verbal orders, through our research, we found that there are many judges that issue verbal orders in the courtroom that impact a defendant's release. In order to capture those verbal orders, we also realize there are many clerks that use different types of forms. They call them minutes forms, or court action forms, or court event forms. And if your county does not use one of these forms that captures the activity that occurs in court on that particular hearing, we recommend that you develop them. The court event form, along with the court verification form, would be prepared by the judge. The clerk would prepare the court event form, and those two documents would be the confirmation that the verbal directive is legitimate. And if your county provides DOC or jail personnel in the courtroom, we recommend that you give them the copies of those orders in the courtroom. If they're not in the courtroom, we recommend, again, the secured process, which would be email the court event form and court verification form to one of those, to your point of contact. This is a Palm Beach County court event form, and it has basic release information and sentence reduction information on it. That place for a motion, whether it's granted or denied, bond reduction, and things of that nature. This is Leon County's, which is very similar type of motion: order granted, denied, bond information, basic information that would cover verbal orders by the court. Written orders, the process is very similar. In court, the judge signs the written order modifying the release, signs the court verification form, provides it to the clerk, and then the clerk provides copies of each to the DOC or jail personnel in court. Again, if your county does not provide those folks in court, we recommend that you email those documents to the point of contact. Out-of-court orders are, again, orders that are received from the judge in chambers. That process is very similar as well. The judge signs the order in chambers. He also signs he or she signs the court verification form, provides it to the clerk. The clerk fills out the bottom part of the form, confirming that they received it, where they sent it, and provides it to the local jail or DOC facility, again, through a secured email process.
Louis, could I stop and just ask a quick question about that? I don't know what other counties are doing in that regard. In Leon County, you end up with practices where you don't know how you inherited them, but sometimes they're good. But in Leon County, when we have judges that are entering the orders to amend sentence or release or those kind of things, the JAs do all the work as far as mailing out. I mean, they're emailing, they're doing that. I mean, and I just wanted to bring that up for the purposes of the group to say, the form there's a bottom section that says for clerk, and we've got conversations going in office about, well, since we're not the one that does that mailing, we obviously are gonna have to talk to some of the JAs or whatnot and figure out how we do that, because we never see that. The judge signs the order, they do the copying, mailing for us, and we just get the file back for filing, so it never even comes back to the court folks. So I don't know if you guys, if anybody else has that kind of issue, but I just want to bring that up so that, you know, when you look at the form, that's just one of those things you'll have to deal with locally, so.
Okay, the bottom part of the form, this is what Gypsy was touching on, is what we determined would be filled out by the clerk. Again, if the JA does it, that procedure may need to be modified slightly. So when the clerk receives the form, it'll be filled out from the court or designee, and the clerk will check off the box whether it's transmitted to the local detention facility or to the DOC, sign it and date it. Okay, that's the entire process for the in-court and out-of-court, and Gypsy is going to speak to direct pickup and not legitimate orders.
I'll just sit. Okay, on direct pickup, we can go to the next slide, I guess. There we go, thank you. This was really to, I don't know if you guys get this, but this was really meant to cover, occasionally we'll have an attorney show up in our office and he'll have the original order in hand that the judge signed. Well, the judge told me to take this and bring it to you. We don't get that a whole lot, but we do get it occasionally. And so that's an outline process that's not secure. It's not coming to you from the judge's JA or a runner. I mean, it's simply an attorney walking in the door. And could that be a fraud? Sure, it could. I mean, you know, you have trusted relationships. You know who your attorneys are for the most part, unless you're just huge, perhaps. But really, this was meant to cover that, so that if you get that, if you have red flags raised, you take that order and you send it back up to the judge with the form, so that the judge can say, yes, this is legitimate, I did sign this, and I did give it to Harry Bob, whatever, to bring downstairs to you. So that's what this was meant to cover, to still use the court verification form, so that you're covered and not just taking something in from anybody at the counter and assuming it's an original order if it may not be. So that was the direct pickup order process. This was really to cover what we do when we get this, and one of the things that we talked about was that when you get the form with the order, you're not just docketing the order. You're going to make sure that you're dealing with your court event form, that you're doing all the necessary data entry from the court event form that you normally do, but now you have one extra document to actually docket, which would be the court verification form, so that you have that on hand, showing in the progress docket. It's in the file, it's scanned, whatever it is that your process is, but then we're actually processing that as well. And then once we actually have all of that, you're engaging in whatever service process that you do to make sure those orders go out to jail, DOC, whoever, so that they get that securely via email and have that court verification form as well. So that's what that process is. For the not legitimate orders, you know, this is tough because, you know, if you're a smaller county, you may know all your judges' signatures. If you're a large county and you have both the judges, you may not. But I mean, you know, it's really about being attentive and making certain that, you know, they come to you in the usual route. It's not the attorney that just shows up with one. It's not something that just shows up, but it's to really kind of check into that. You will send that, if you find something that is not legitimate, you don't recognize a person's signature or whatever, you do need to notify your chief judge. We recommend that you also phone the detention center at DOC, so that if they've gotten any kind of order like that, they're not acting on that. You're letting them know as soon as possible, ooh, that's, you know, we're looking into that, wait till you hear back from us. And then to follow up again by actually sending out the court verification form when the chief judge has said that it's not legitimate. Okay, so I guess we can move on to the next slide. Yeah. And this is just kind of summarizing what we've said all along, is that making sure that the new form is actually docketed into your case maintenance application, making sure that it always is with whatever the order is, that's, you know, amending the sentence, releasing, or whatever, and that, you know, as your court clerks are very good at doing, if you're in there and the judge is saying things, you're putting that on your court event form so that you have some kind of backup to say, verbal order, wrote on the minutes, and this is why this transpired. As far as our recommendations, It's like most of our best practices to always communicate with everybody that's involved in this, you know, in the issue. And so it's really important to make certain that you involve your JAs, your judges, your detention facilities, everyone, to make sure they understand why we're doing what we're doing. And we're not trying to complicate anything, but we're trying to be appropriately responsive to issues that have come up that were all throughout the media. And then, you know, even though this is a best practice, to make sure that you have, you know, specific policies and procedures on hand in your office for staff so that they know what to do. Can we go to the next one? And we, the second bullet really is, we recommended that the most experienced clerks process these so that the first bullet can happen. They actually can not only just process it, but they also have the tenure in the office to be able to validate that these are correct and this is what they're used to saying and the signatures are correct. The third bullet, so that, you know, it's not someone new that wouldn't know what to do with it, but it's someone who's been in the system long enough and has interacted with the folks long enough to know, to have good common sense about whether something is legitimate. And then for training, that was training, and then, we talked about the non-secure drop boxes. I don't know about you guys, we have a really, really nasty looking, old postal box thing that's hand wide behind the courthouse. We've had it there for years. We were hoping to make it go away with e-filing, but we still have it there. People will occasionally drop payments, motions, those kind of things. We have an experienced mail person in our office who picks up all the mail, and if she got something weird in there, she would know to say something to us, but again, it's back to having experienced personnel. It's usually just for people to drop motions and that kind of thing. If we were to ever get an order, that would be something, a red flag, that judge is going to walk outside with a nasty mailbox and get it. No, I don't think so. So, I mean, it was just really to say, really look at your office, see where you have these non-secure areas. Do the JAs or the runners drop things in just people's mail bins on their desk, or is there a designated area? And if there is a designated area, how secure is it? Who can get to it? It was really to examine that and make certain that if you're certain the security is there, then you're able to proceed. But if not, if you have those, you really need to look into those and process those with the form and send those back upstairs if you're not sure that they're legitimate. So.
And Gypsy, if I may add another recommendation, one of the things that we would also ask you to consider is actually the removal of drop boxes altogether. Now with e-filing, both in civil and criminal courts, we felt that the need for drop boxes is no longer valid. So we did remove those. And we also provide electronic image access to our jail facility and our DOC. So they're able to, if any of this process should break down, they can actually go into our case management system and pull up the case and actually see images of anything that's documented. So that's another verification process you may want to use. And as Gypsy said, having the clerks that process these orders have a list of the judges' signatures and or their designees near them would help too, so they get familiar with the signatures on the orders that they receive.
And back on the drop boxes, you know, it's an issue that you wrangle with because even with e-filing, you still have a substantial pro se contingent, or at least we do in Leon. And so, you know, my clerk still wants to provide that box for that purpose, but then it absolutely adds a level of complexity to you as far as the legitimacy of things that may be dropped in that. We always have to be sensitive to that, no question, absolutely no question on that. Questions, comments?
Are the forms that you're showing there, are they some kind of best practice forms, or is it, so the county does their own?
They'll be in the best practice, it's just a recommendation at this point, but absolutely. Yes, sir?
A lot of what you talked about is our orders from judges, and obviously that would more involve the DOC, but we get far greater amount from the state attorney's office for the jail of releasing people. What did your best practice committee come up with on that?
Do you want to speak to that?
Yeah, the null process is what you're talking about, Clerk. Null process is no files. And our recommendation is that the state attorney file those directly, email those orders directly to the local jail facility.
We talked about putting it in the best practice, and then we were trying to figure out, you know, the best practices for clerks, and we really can't direct other offices. But that was why we left with saying, communicate with your state attorney. Certainly say to them, you're gonna do a no information or a null cross, yes, we're gonna get it, yes, we're gonna, and yes, we'll do the data entry work, and if the jail's accustomed to going in or looking at something real time and running a
I'm
report.
gonna say that analysis goes for the clerk, I think, first, Teresa.
Yes.
And then we're the ones who notify the jail. The state attorney would notify the jail.
Well, and that's another reason I think why we really didn't speak to that is because the state attorneys have worked out different things in different areas. And so it was really just to make sure you have that communication. If your state attorney is used to communicating it, great. If you are, that's great. But clearly with release documents like that where it's not actual orders coming from the judge, someone needs to be telling the facility. I know in Leon, we don't tell them, but the jail has real-time access to our integrated database, and they have reports and they look down on a regular basis, so they consider that theirs.
Again, maybe I didn't articulate my question well. It's more, how do we have secured transmission? Have you come up with a best practice on the state attorney communicating that information to the clerk?
No, we did not address that.
Gypsy, what are the thoughts about the state attorney using e-service? Because the majority of them are moving to using the portal, and that provides them with the opportunity to do e-service. So why couldn't they send the update to the local jail?
I think they could, but that goes back to your slide, which says, make sure that you develop points of contact at the state attorney's office, at the jail, at whoever, so that if the state attorney's out on the e-portal and doing the no information, once they go to the service page, absolutely, whoever their point of contacts are, and I recommend more than one, because if that person's out sick or something like that, absolutely, they can do it that way. It's just about developing those points of contacts and having communication. I like that.
Many of our agencies actually have developed singular mailboxes, not unique names, so that their employees can go in and obtain the information. So that's another suggestion for the other counties.
That's a great idea. Yes, sir.
What is your definition of a secure email? I heard that you said that when you said a court order has to go to a secure email.
Yes.
So what constitutes secure? Because for me, email is not secure from the IT perspective.
We mean to a specific email box identified by either the DOC or the jail facility.
Okay, maybe you should consider authentication solutions, for individuals like PKI or fingerprints or any other. If you want to make it secure, that's what I'm saying. To identify yourself that you're saying that.
No, I mean you make a good point, but we were really just focused on instead of it going to a mass email or something like that, making sure you have the points of contact for the people who need it, who can act on it immediately. But I mean, your points are well taken. I mean, you can take it those steps further.
It's just the definition of secure mail for me. It's like
lawyers and IT people, we put special meanings to certain words, don't we? Yes, that's a good point. Thank you. Yes, sir.
Lewis, I can spoof an email to you, and you think I'm President Obama, and it would get into the Palm Beach email system, and probably anybody's around here. There's a problem with email systems. They really don't check who the from address is from. So you're going to have some physical association that's coming from this physical judge's computer system based upon his physical IP address. Otherwise, this gentleman's correct. Your email stuff is absolutely not secure by itself. We do it all the time as jokes at our office. I'll be happy to send a couple of jokes.
It's a valid point, and I mean, we didn't have IT folks on the work group, but we could, since it's just a recommended state, I mean.
No, I think it's perfectly 100% right.
It's a good point. I mean, and even in that world, I imagine there would still be recipients of it who would want to call or something and say, or sign on themselves and go into the case maintenance applications to verify. So, I mean, you can take this way far.
To clarify again on the court verification form, are you looking for that only when it's a modification, reduction, et cetera, to the jail term or the prison term, or are you looking for any and all modifications to the sentence? Because it wasn't clear, I think, in the early slides.
Well, it was only for anything that impacts one's release time. If it shortens it for any reason, that's what we would be focusing on.
All right, thank you. Just wanted to clarify.
That's a good question, because we had to come up with a work group, what do we want it to apply to? I mean, so.
Do we also say this is something that goes into effect once the bill is passed? Or are we looking to implement this prior to?
Well, it's interesting because you got the bill, and then we also heard that the Chief Justice of the Florida Supreme Court is going to address the issue, likely by its usual administrative order process. So, I don't know.
And we're going to, once we find out what the administrative, the admin comes up with. We're not gonna wait till the bill gets passed, because if the bill doesn't get passed, we still need best practices for the clerks to protect on this. But before we finalize this best practices, we will wait until the admin order comes back. And, you know, judging from whatever the admin order states, we'll make sure that we have that in defiance about best practices.
Well, since the DOC is already sending a version of a verification form, do we envision that one will go away and replace with the other, or do you have any thoughts or insights?
We didn't really talk about that. I mean, I don't know how we went in other counties. We were talking about this a little bit yesterday. I know that the DOC form just showed up in Leon, and one told us it was coming. And DOC assumed incorrectly that I was gonna do all the data entry on that and save those forms. And we said, no, that's something between you and the judge. You do with it what you want, and if it shows up with me, I'm gonna throw it in the DOC box. And y'all can take it back, because I'm not gonna do anything with it. So, I mean, I hope there's some coordination of that, because, I mean, I imagine at some point, the judges are gonna go, I have to do this form, that form, and this form. I mean, so, I mean, I hope so. I hope there's some kind of coordination on that. Yes, ma'am.
Good morning. I just was curious, have you discussed, you know, since we are going to be providing these forms outside of our office, they will become public record, the potential for those being fraudulent as well? Because, you know, you have the judge's signature on the order, and the judge's signature on the verification form, and I don't know if there was anything that was discussed as a potential validation of the verification form.
We didn't have the verification form of that one, okay?
I mean, it was something we discussed internally too, like, so if somebody's gonna, you know, create a fraudulent order, they're probably gonna, you know, create fraudulent document as well.
I think the thought in the process is that the court verification form and order are hand-delivered basically to the clerk, either in the courtroom or from the judge chambers, where either the clerk goes to pick it up or the JA county. In our county, the clerks go and pick it up.
Right.
So those orders would be together and would be basically hand-delivered.
Yeah, I think the only thing that we had talked about that would be, just like you said, the Dropbox would be odd. So just, are you guys sending those back up to the judge with a verification form if you were to get one in the order? How are you doing that?
That's what we talked about. I mean, we have, you know, it's interesting when you start talking about these things in your office, you start thinking, well, where are your proverbial holes in the diet? You know, because you really, that's what you're looking for, is how to, you know, winnow down that number so that doesn't happen. So, I mean, we haven't even finished all these conversations. My folks are still just like, so, yeah, I mean, but that's a good point. That's a very good point. Anybody else? Well, thank you, guys. Enjoyed speaking to you.